So for the record, this is from the law offices of Stephen A. Torres of Taunton, Massachusetts, dated March 29th, addressed to Mr. Andrews, Town Administrator. Reason: computer audit and imaged hard disks, Town of Wareham. Dear Mr. Andrews, our firm provides this letter at the board's request to review a series of events and communications concerning the computer audit and possession of certain image disk drives seized by the Plymouth County District Attorney's Office for the purpose of a convened grand jury during the fall of 2009. No indictments were issued by the Plymouth County Grand Jury, and no explanation has ever been provided concerning the reason for the original seizures of the municipal hard drives and summonses of town employees, including a selectman and a town administrator, to appear before the grand jury. Excuse me. Attorney Jack Units provided representation at those proceedings. There was no factual basis or indication from the District Attorney's Office to ever suggest that the individuals who appeared as witnesses before the grand jury, which would be myself and Mr. Sanjanet, were subjects themselves of the investigation, and that no criminal charges resulted, substantiates the fact that at no time did any member of the Board of Selectmen engage in any improper conduct through seizure of the disks and initiation of the computer audit in their oversight role as the executive branch of town government. On or about January 18th, our office became aware that the District Attorney's Office would be releasing the disks previously seized in conjunction with their grand jury hearings. By facsimile transmission on February the 2nd, 2010, a copy of the letter announcing the return of the disks was forwarded by Attorney Jack Units, who handled the grand jury matter on behalf of the town, to my office as special town counsel for the computer audit. Subsequent to receipt of that letter, I arranged to meet with the Board of Selectmen and met on February the 9th, 2010. Then and now, my concern was to limit the number of handlers of the disks to preserve chain of custody, and I informed the board that the disks would not be picked up until we had the firm who would be continuing the forensic audit on board to both retrieve and analyze the disks. I made it very clear that chain of custody supported having a firm under contract to do the analysis before the disks would be picked up from the DA. At that point, the town administrator and I were going to make inquiry to potential firms to handle the influx of 74 disks in need of rapid analysis due to the untoward delay of the original computer audit by the unjustified seizure of the disks by the District Attorney's Office. After the town administrator and I attempted to secure services of other forensic firms, in late February my office was able to secure the continued services of Global Digital Forensics to conduct the retrieval and analysis of the disks. We then placed 2 calls to the District Attorney's Office to arrange retrieval of the disks. On March 19th at 2:21, Louis Armistead from the District Attorney's Office left a voicemail indicating that he had been on trial and was unable to get back to me earlier, that he had been on trial and wanted to make arrangements to get us the disks. Unable to reach each other directly, excuse me, in a series of subsequent calls, I left specific, detailed instructions on Assistant District Attorney Armistead's voicemail that the disks were to be released to Fred Secure at Global Digital Forensics, the town's authorized agent. We then directed Global to contact the Assistant District Attorney to make arrangements for retrieval of the disks and execution of the chain of custody forms. It was at or near that time that Global assured us they would be available the next day to retrieve the disks. It was at or about this time that I communicated, perhaps in anticipation and error, to the town administrator that the disks were being picked up by Global. Subsequent to that, however, the Assistant District Attorney informed Global, but no one communicated to me at that time that the District Attorney's Office in fact would not release and would only release the discs to counsel and not to the forensic investigators directly. This caused a further delay in obtaining custody of the discs. This summarizes the sequence of events that led to the delay of receiving discs, and at no time did the Board of Selectmen take any action that caused that delay. At all times, the Board had been anxious to bring closure and through the Town Administrator, has been in regular contact with our office. In addition, reference is made to the Assistant District Attorney's January 13, 2010 letter that this matter has been forwarded to the State Ethics Commission and the Office of the Inspector General of the Commonwealth for their review. The State Ethics Commission is empowered to enforce upon strict statutory and procedural guidelines the State Conflict of Interest Law for public employees and officials, Chapter 268A. Upon receipt of a complaint that an individual subject to that law has committed a violation, the State Ethics Commission must notify that individual of the complaint. No member of the Board of Selectmen is subject to a complaint before the State Ethics Commission, or the individual would have received such notice. To surmise from the District Attorney's letter that a complaint about the Selectmen was made is to ignore the strict procedures adhered to by the Board. With respect to the portion of the letter concerning a matter involving the discs being referred to the Inspector General's office, that office enforces the public procurement statutes, and our office and your Board are currently working closely with them on review of a matter, again, in which the Selectmen are a reporting party and not a party subject to any investigation. I trust this answers any questions regarding this process to date and status of the computer audit. Sincerely, Steve Torres. So I reiterate again, and for the record, we're not subject to any investigation. The IG is conducting their own separate investigation. We are cooperating in every way possible with that investigation. The discs did not sit there in January idly while this Board did nothing. We did everything we could to retrieve those discs. The story here is not what the chain of custody of those discs was and the date that we picked them up. The story here is why were they confiscated in the first place. There is no legitimate legal reason that has ever been explained to us as to why those discs were confiscated. Where are we now? This Board has decided that we will move forward under the terms and conditions of the original global forensic contract in Phase 1, as we call it, and we'll move on with this audit as we should have and as we are responsible to do, both under the law and under the Charter and in the spirit of our office. And that's where we are up to the minute. Any questions or comments from the Board?